lecture series, Hon'ble Mr. Justice Madan Bhimarao Lokur, Judge, the Supreme Court of Fiji, former Judge, the Supreme Court of India. Respected Chancellor Sir, Uttaranchal University Shri Jitender Joshi, Vice Chancellor Professor Dr. N.K. Joshi, Principal and Dean, Law College Dehradun, Professor Dr. Rajesh Bahuguna, Professor Dr. Poonam Rawat, HOD Law, faculty members, external participants, ladies and gentlemen, a very warm and pleasant morning to all of you. I, on behalf of Law College Dehradun, welcome you all to this wonderful and enlightening law lecture by legal luminaries on the topic Constitution and Social Justice. Moving further with the event, I request Chancellor Sir and Dean Sir to kindly felicitate the guest. Thank you, sir. For the University Kulgeet.
Honorable Mr. Justice Madan Bhimarao Lokur, the Chief Guest, and keynote speaker of this lecture series. Honorable Chancellor Shri Jitender Joshi ji, Honorable Vice Chancellor Professor N.K. Joshi ji, Head of the Department of Law, College Dehradun, faculty members, my dear students, participants, and media persons, both electronic and print media, I am taking this privilege to welcome you on the behalf of, firstly, the Training and Recruitment Division of the University responsible to organize this lecture series, and also Law College Dehradun and entire Uttaranchal University family. You all are welcome here. Introduction of Honorable Mr. Justice Lokur is not new to us and to entire country, but as I will ask to introduce him. Lordship was born on 31st December 1953. Graduated in History Honours from St. Stephen's College, Delhi University in 1974. And obtained law degree from Faculty of Law, also from Delhi University in 1977. Enrolled as an advocate on 28 July 1977 and practiced in the Supreme Court of India and the Delhi High Court. Qualified the examination of and enrolled as an advocate on record in Supreme Court of India in 1981. Lordship has vast experience in civil, criminal, constitutional, revenue, and service laws. Lordship was appointed as the Standing Counsel for the central government and remained there from December 1990 to December 1996, during which period had handled all kinds of cases on behalf of central government, including criminal trials in respect of economic offences. In February 1997, Lordship was designated as senior advocate. On 14 July 1998, Lordship was appointed as Additional Solicitor General of India and continued as such till appointment as an additional judge of Delhi High Court on 19 February 1999. The Lordship was appointed as permanent judge of Delhi High Court on 5th July 1999. Lordship functioned as the acting Chief Justice of Delhi High Court from 13 February 2010 to 21st May 2010. He served as the Chief Justice of Guwahati High Court from 24th June 2010 to 14th of November 2011, and also Chief Justice of High Court of Andhra Pradesh from 15th November 2011 to 3rd June 2012. In June 2012, Lordship was elevated as Judge of the Supreme Court of India. Was appointed as one-man committee to suggest improvement in the working of homes and organization under the Juvenile Justice Care and Protection and Children Act 2000 and Juvenile Justice Care Protection of Children Rules 2007. Honorable Mr. Justice Madan Bhimarao Lokur is known for his keen interest in juvenile justice, judicial reforms, along with judicial education, legal aid, alternative dispute resolution system. He has been member of Mediation and Conciliation Project Committee and judge in charge of e-commerce in the Supreme Court of India. Some of the landmark judgments by Lordship include Ashwani Kumar versus Union of India, where he directed the government to ensure that elderly people's rights under Article 21 are properly enforced. Inhuman conditioning, 1,382 prisons. In Re-Independent Thought versus Union of India. Nipun Saxena versus Union of India. Rajendra Pralhadrao versus State of Maharashtra. And so many series of cases. Ladies and gentlemen, it's a great honor for all of us and for the entire country that Lordship is currently serving as Judge of Supreme Court of Fiji. My Lord, your benign presence made all of us proud. And this university campus, which include top management, faculty members, staff, students, and all participants, and even myself, after reading your CV and introduction, are greatly honored. So, on the behalf of entire family, I take the privilege to welcome you from the bottom of my heart. I would like to welcome in absentia Madam also. She couldn't come here, but she is also in our campus. So, in absentia, I welcome her also. I welcome Honorable Chancellor Sir, Vice Chancellor Sir for joining us today and entire participants and faculty members today. Ladies and gentlemen, about this event, this is Law College Dehradun lecture series by legal luminaries. We started 3 years before. And aim is that all the legal luminaries from India and abroad, honorable judges, professors, subject experts, people from industries, we are inviting them here so as to have direct interaction with the students. And let me tell you, this seminar hall of Law College Dehradun has witnessed series of legal luminaries for which we all feel proud, and our students have got direct interaction with the honorable judges of Supreme Court, High Court, professors and people from industry. And today's seminar or today's work is, the specific topic is Constitution and Social Justice. So, now Lordship will address first to the gathering on this topic, and after that there will be an open session. All students, faculty members and press, whoever like, they can have questions with Lordship, and with this may I request Lordship Sir to come for his word of wisdom.
Thank you very much. Respected and Honorable Chancellor, Mr. Jitender Joshi, the respected and Honorable Vice Chancellor, Dr. N.K. Joshi, Principal and Dean of the Law College, Dr. Rajesh Bahuguna, the Head of Department, the faculty, my dear students, persons from the media. But thank you very much for giving me this opportunity to share some thoughts on the Constitution and social justice as a part of the lecture series that you have been having for the last 3 years. I think it's a remarkable achievement, and it's a remarkable opportunity for all the students to interact with a variety of judges, legal luminaries, professors, academics and so on. And I would request all the students to continue this interaction and even after you conclude your studies, because I think it is through dialogue, discussions that all of us learn. And I can tell you that those of us who have done law always believe that we are students of law for the rest of our life. So it's not that after you've got your LLB degree, that's the end of it. It's not like that. You will be students of the law for the rest of your life. On the topic of the Constitution and social justice, I would like to first draw your attention to the Preamble to the Constitution of India. It's a very, very important document, and it talks about justice, social, economic, and political. It also talks about liberty, equality, and fraternity. But for the present moment, I think social justice is one area which is of immense concern to all of us. And the Constitution of India has recognized a series of activities, if I may call them, and a series of institutions which are a part of the basic structure as defined by the Supreme Court in Keshwanath Bharati's case. So the rule of law, for example, is a basic feature of the Constitution. Independence of the judiciary is a basic feature of the Constitution. Free and fair elections is a basic feature of the Constitution. And equally important is the separation of powers. That is also a basic feature of the Constitution. Now, what do we mean by the separation of powers? You have a system which was propagated during the French Revolution and which has been implemented in the United States of America, where you have a very rigid separation, where you have the legislature, you have the executive, and you have the judiciary. They're all separate. But in the Westminster model that we have adopted in our country, that rigidity is not there. So you have persons from the executive who are members of parliament, for example. So the cabinet, which represents the executive, is answerable to parliament. And of course you have the judiciary, which is completely separate. But broadly, the idea is that the legislature, whether it is parliament or whether it is the state legislature, the legislature will enact laws, the executive will implement those laws, and the judiciary will interpret those laws. These are the three basic pillars of democracy. But the problem arises when there is a failure by the legislature to enact a law. So you have a given situation and there is no law that is enacted to deal with that situation. That's one category. There's another category where there is a law, but the executive does not implement the law in letter and spirit. In a situation like this, in both these situations, where there is no law and where there is a law but not being implemented by the executive, what is a citizen supposed to do? He or she can't go to parliament and say, please enact a law. That's entirely the prerogative of parliament. He or she cannot go to the executive and say, well, there is a law, why don't you do something about it? If the executive does not do anything about it, that person is helpless. That's where the judiciary comes in. That's where the courts come in. And over the last several years, I will be dealing with some of these cases. Over the last several years, the judiciary has been reacting to these kind of situations where there is no law or where there is a law but is not being implemented by the executive. So in that sense, the theory of separation of powers has got somewhat intermingled. And that is why occasionally there is criticism about the judiciary to say that, well, there is judicial activism, there is judicial overreach. Are the judges going to run the country? No, the judges are not going to run the country. It is parliament and it is the executive that is going to run the country. But if they don't do their job, can a citizen come to the Supreme Court or to the High Court and say, well, please do something, and the High Court will say, sorry, we can't do anything. There is no law, what can we do? So to that extent, the separation of powers theory has been diluted. This actually led to the beginning of public interest litigation. That's how it started. Among the first few cases was filed by an NGO called Bandhuwa Mukti Morcha It was actually a letter that was sent. It was not even a petition that was filed. It was a letter sent to the Supreme Court, and the Supreme Court treated that as a writ petition under Article 32 of the Constitution. Now, what the NGO said, Swami Agnivesh, on behalf of that NGO, what he said was that the Constitution of India, Article 23, prohibits begar, which is to say forced labor or bonded labor. It is unconstitutional. It's prohibited by Article 23 of the Constitution. Yet, in Faridabad district, right next to Delhi, there are bonded laborers. Persons who are working in mines, their father or grandfather or somebody in the family, 1 or 2 generations removed, had taken a loan and was unable to repay that loan, and therefore is being forced to work under unhygienic and all kinds of deplorable conditions to repay the loan that was taken by somebody's father or grandfather. That is bonded labor. There is also a law enacted by Parliament called the Abolition of Bonded Labor Act. That is not being implemented. So there is a violation of a constitutional provision, Article 23. There is a violation of a law enacted by Parliament. And yet, in Faridabad district, right next to Delhi, bonded labor is going on. So here was a situation where there is a law but not being implemented. So Bandhuwa Mukti Morcha wrote a letter to the Supreme Court and said, please do something about it. And the Supreme Court said, in the interest of social justice, which is a part of the Constitution, is a part of the Preamble, we have to interfere. If the executive is not doing its job, is not performing its constitutional obligation, the citizen cannot be left without a remedy. And so the Supreme Court intervened and passed directions, and eventually almost about 30,000 bonded laborers in and around Faridabad district and 1 or 2 districts nearby got freed from bonded labor. The unfortunate part is that even today, I'm talking about a judgment delivered by the Supreme Court in the 1980s, even today, 40 years later, we still have instances of bonded labor in different parts of the country. This is, to my mind, a failure of the implementation of the law by the executive, where the Supreme Court is compelled to intervene. I'll give you another case, also of the early 1980s, from Dehradun. There is an NGO over here called Rural Litigation and Entitlement Kendra, RLEK. Again, RLEK wrote a letter to the Supreme Court and said that in the Masuri Hills there is quarrying of limestone that is going on. And it's illegal according to RLEK. But the bigger problem is not about the illegality of the quarrying, but the fact that limestone dust is being generated by these contractors. And that limestone dust is coming into Dehradun. And we in Dehradun, because we are at the lower level, we are having to breathe polluted air. There was no law. The Environment Protection Act came later. There was no law. Yet the Supreme Court said we will intervene. And because the right to breathe fresh air is a part of our life and liberty, we can't be compelled to breathe polluted air. The Supreme Court said we will intervene. They appointed committees and eventually a task force and so on. And the quarrying of limestone stopped, and the pollution in Dehradun came to an end at that point of time. So here you have two contrasting situations. One of Bandhuwa Mukti Morcha, where there is a law but not being implemented. Second, of RLEK, where there is no law but there is a problem with the citizens, and intervention by the Supreme Court. These are two different aspects of social justice, and how the Supreme Court has given life to social justice, which is a part of the preamble of the Constitution, and it has given life to Article 21 of the Constitution to say that life does not mean just living. It means something more. It means living with dignity. That was really the beginning of the dignity jurisprudence which was developed a little later. Now, I will give you some instances of the failure to make a law by Parliament, and yet there is intervention by the Supreme Court. One of the more prominent cases is that of Vishaka. I'm sure all of you have heard of that case. India is a signatory to the International Convention on the Elimination of Discrimination Against Women. One of the elements of that is sexual harassment at the workplace. Now, there were allegations of sexual harassment at the workplace, but there was no law. Supreme Court said that India is a signatory to CEDAW. And even if there is no law, we have international obligations. Why have we signed that treaty? Why have we signed that convention? We have signed that convention because we believe, in India, we believe that there should not be any sexual harassment at the workplace. So what if Parliament does not enact a law? Does it mean that it's alright to sexually harass women at the workplace because there is no law? So it's perfectly alright. I mean, nobody is doing anything illegal. Supreme Court said, no, sorry, that's not the way to look at it. Even if there is no law, the fact of the matter is that we are signatories to an international convention. The fact of the matter is that this is a violation of the dignity of women who are at the workplace. So therefore, even if Parliament does not enact a law, we will give some guidelines on how to deal with cases of sexual harassment. Now, this happened in 1998 or 1999. When did Parliament enact the law? The Parliament enacted the law in 2013. It took 15 years for Parliament to enact the law. Now, it is nobody's case. Nobody can ever say that because there is no law, therefore, sexual harassment of women in the workplace is justified. Nobody can say that. But in spite of that, Parliament did not enact the law. So, is a citizen helpless? Supposing a lady comes and says that I am being sexually harassed at the workplace. Can the Supreme Court say, well, bad luck, we can't do anything. There is no law. You deal with it yourself, do whatever you like. We can't help you. The social justice component of our Constitution does not forget that. Article 21 of the Constitution does not forget that. And that is the reason why the Supreme Court intervened. Similarly, you have the rights of gay persons. When the matter first came up to the Supreme Court said that we don't want to say anything on the subject. Let Parliament enact a law. Let Parliament look at Section 377 of the IPC. For 2 years, Parliament did not do anything. Theoretically, gay persons could have been prosecuted by the police for violation of Section 377 of the IPC. Again, a violation of their life and liberty, personal liberty. So, in spite of the fact that Parliament did not enact a law, the Supreme Court said we can't let this situation continue. And when the matter came up in review, the Supreme Court read down Article Section 377 of the Constitution. So here again you have a situation where Parliament does not enact law, but the social justice component of the Constitution has to be implemented. And that is where the Supreme Court has intervened. And that is where the Supreme Court has given life to the Constitution. On 26th of November 1949, Babu Rajendra Prasad, who was the President of the Constituent Assembly and later became the first President of India, he said that a document like the Constitution is like a machine, it's lifeless. There is no life in the copy that I have before me. But you have to breathe life into it. It is nevertheless a living document, and how do you breathe life into it? You breathe life into it by giving it a constructive interpretation. And that is what the Supreme Court has done right from the 1980s onwards. I will give you some examples of laws having been enacted by Parliament but not having been implemented in the different spirit. by the executive. Again, what does a citizen do in a situation like that? We have something called the Manrega Act, Mahatma Gandhi National Rural Employment Guarantee Scheme, and an act. Now what that law says is that it guarantees 100 days of employment to one person in a family. There were instances, and that came up before us in the Supreme Court before the Social Justice Bench. Persons who had worked under the scheme and who were entitled to wages were not given their wages. They had to ask the authorities once or twice, how one can give me money, and the authorities said, yes, we will give it to you. The money has to be given within 15 days, not transferred within 15 days. After 15 days, interest has to be paid. So forget about the wages, even the interest was not being paid. On their behalf, petitions were filed, saying that there is a law. The law says that you give the money within 15 days. Alright, if you can't give the money within 15 days, give it after 15 days, but pay interest. But unfortunately, the authorities, whoever they were, from the state or the central government, wherever it is, they were not implementing the law. The executive was not implementing the law. Again, what does a citizen do? A person who is unemployed, a person who is working for earning a living, who is perhaps illiterate, definitely staying in a rural area because the act is applicable to rural areas. What is that kind of a person supposed to do? So he comes to the court and says, I have a right which has been given to me by law but not being enforced by the executive. Please pass appropriate orders. And the Supreme Court says, yes, we will pass appropriate orders. That is then misinterpreted by the executive to say that, well, are you running the country? No, the Supreme Court is not running the country. You are the ones who have to run the country. You are the ones who have to implement the law. The law is being made by Parliament, the supreme legislative body. If you don't implement it, a citizen can't be left without a remedy. That is the basis for this intervention under the Manrega Act. You have something called the National Food Security Act, a legislation of 2013. When the petition came up before us, we were surprised to find that some state governments, not some, quite a few state governments, had not set up a food safety commission. Whose job is it? It is the job of the state government to set up the food safety commission. What is the purpose of this food safety commission? To ensure that there is food security, that everyone gets food. Now, a person who does not get food because of non-implementation of the law, if he comes to the court and says, well, I am not being given food because the law is not being implemented, can the Supreme Court say, bad luck? If you have to die of starvation, die of starvation. How does it matter to us? The law is to be implemented by somebody else. Separation of powers doctrine. It's not our job to implement the law. Again, Supreme Court said, no, we can't leave that person without a remedy. And directions were given, and it took a long time, about a year, for some of the state governments to actually establish those food security commissions. How they are working is a different matter altogether, but at least the authorities are in place. Similarly, under the Manrega Act also, authorities in some places were not existing, but then they were eventually put into place. Manual scavenging, you would have read about that in the newspapers a few days ago. There has been some discussion going on about that. Again, prohibited by law. The law says that there should be no manual scavenging at all. It's a dirty, dirty job. It defies the dignity of an individual. And Parliament has said, no, they cannot be manual scavenging. Supreme Court has said they can't be manual scavenging in interpreting the law, but you still have manual scavengers. So these are, areas of social justice where there is no option for the court but to be proactive. There is no option except for members of society, NGOs, others, people like any one of us, to approach the court and say that some meaning has to be given to social justice, which is a part of the preamble. And the Supreme Court has to give life to the preamble, it has to give life to the Constitution and say that yes, if there is a social problem, we have to intervene and we have to do something about it. There is a third category of situations that arise where it's a social problem that exists. Perhaps it cannot be legislated upon, and definitely there is no legislation. I will give you examples of two such instances. One is with regard to widows. Now, for some reason, there are a very large number of widows in Vrindavan. According to one newspaper report, I don't remember the figures, it was about 30,000 widows or 50,000 widows in Vrindavan alone, cut off from their family. Why they were there, I have no idea, but there are a very, very large number of widows. They have no source of income. They have no place to stay. How do they eat? Where do they get their food from? They have to go to the temples in the morning, sing bhajans, and they are given prasad, which is virtually their breakfast. In the evening, in the afternoon, they have to go to the temples again, sing bhajans, they are again given prasad, that is their lunch. Late evening, again they have to go do the same thing and they are given their dinner. This is how they survive, because they have no income. And sometimes you will find if you go to Vrindavan, some of them are begging outside the temple for some money. Where do they stay? There might be some dharmshala somewhere. They have to stay over there because they don't have a roof over their head. The court was involved in the rehabilitation of these widows. Again, no law. And directions were given to the state of UP, to the Women and Child Department of the government of UP to do something about it. And the government of UP realized that there is a very serious problem. How are these widows going to live with dignity, which is an essential part of Article 21 of the Constitution? And through discussions, through reports, with the assistance of the District Legal Services Authority, with the assistance of the UP government, NBCC, National Buildings Construction Corporation, a huge hostel kind of a structure was built up. Bank accounts were prepared and given to these widows. Clothes were distributed, blankets were distributed. So here again is a social problem. There must be some historical reason why they come to Vrindavan. We have got them in Jagannath Puri as well. So these are all, elements of social justice. You also have situations in prisons. Again, there is a Prisons Act, but it doesn't say how prisoners are supposed to be treated. You have jail manuals. Those jail manuals were prepared when the British were ruling the country. They have provisions which require handcuffing. So a person accused of an offence, there is a presumption of innocence. A person accused of an offence is taken to court in handcuffs. And people will say, "Acha, ye to badmaash hai." You have persons who are on bar fetters, so both their ankles are tied and their hands are handcuffed and they have to move around like that. It's painful and very difficult to move around. Supreme Court said that even prisoners have rights. Fundamental rights are not available only to persons outside prisons, they are available to persons who are inside prison. They may not have the of freedom of movement that you and I have, because they have to serve a sentence within the prison walls. But other than this, freedom of movement, they have all the other freedoms that are available to everybody else. Importantly, they are also entitled to Article 21 freedoms. That is dignity in jurisprudence. It is not at all dignifying to an individual if that person is put in bar fetters. So the Supreme Court said the system of bar fetters, colonial legacy, should go. Solitary confinement, except for persons who are on death row. Supreme Court said keeping a person in solitary confinement is virtually like torture, and it should not be permitted. So these are instances, where there is no legislation. Parliament may or may not enact a law. There are guidelines. There are procedures that have evolved over a period of time, but which must be constitutionally valid, because our constitution recognizes certain basic principles. And if it entrenches upon the separation of powers, so be it. Otherwise, a citizen will have no right left at all, and that citizen, will be virtually without a remedy. So these are, issues that keep arising from time to time. I would also like to mention, some instances where similar sort of, events have occurred. We had to deal with a case of forced sterilization. Sterilization camps for population control and so on had been established in one particular state. And it was found that women were being sterilized, their reproductive rights were being taken away. Why? Because the quota was fixed. Doctors were told that you have to sterilize 100 women in a month. Now, whether the women wanted to get sterilized or did not want to get sterilized was besides the point. Many of them were illiterate. They did not know what is the consequence of being sterilized. They were not educated on this subject. They were given some money and said, "Kuch operation ho jayega, usi koi farak nahi padta," and they were sterilized. Where were they sterilized? There were instances of sterilization camps being held in schools. So on the school table, in a classroom, under a light, the quota was being fulfilled. Now, again, this is an aspect of social justice. What about the rights of those women? Was there any discussion on this? Were they told? Were they educated? Was there consent taken? We talk about informed consent when we study the Contract Act without any semblance of informed consent. You have the rights of children. Are we looking into the rights of children? They constitute about 38-39% of the population of the country. And when we talk about 38-39%, we are talking about something like 400 million or 450 million children, which is more than the population of many countries across the world. What about their rights? So you have the Juvenile Justice Act, you have observation homes, you have children's homes, you have joint JJBs, Juvenile Justice Boards, child welfare committees. Are they functioning in accordance with law? I would urge you that if you get the time, maybe on a weekend or maybe on some other occasion, please try and visit the observation home over here in Dehradun. See what the conditions are. I had occasion to visit the observation home in Delhi. Delhi is one of the more progressive places where juvenile justice laws are being enforced. When I had gone there some time back, I went to the home. they had 4 dormitories. And I asked the person in charge of the observation home, what is the capacity? He said, well, each dormitory can take about 25 children. So 4 into 25, about 100 children could be accommodated in the observation home. The number of children actually there, physically, was 258. So it was overcrowded by 250%. I requested the Juvenile Justice Board, I said, please take out the cases of all these 258 children. Find out whether they should be there or they should not be there. Now, this is the condition, in which some of our children live. You have some children who need counseling. People are not born criminals. Nobody is born a criminal. Society converts them into a criminal because of a variety of factors. There could be domestic violence in the home. There could be some other problem in the house. There could be the use of drugs. There are a variety of issues that arise. But we must look into these social issues. If we don't look after the children, young children, 10 years, 12 years, 14 years, 16 years, if we don't look after their welfare, they'll grow up one day, 10 years later, 15 years later, and they will remember the kind of treatment they got when they were in an observation home. And even if they are not criminals, there is a possibility that they might become criminals. So rehabilitation, reintegration into society for children, for prisoners, these are all aspects of social justice. After what are we trying to do? We are trying to bring them back into society. They have gone astray, that's why they have committed a crime. It doesn't matter if the person is an adult or the person is a child. The fact is the person has gone astray and we have to get them back into society. You have women who are in jail and who have children. Now, a child has to spend the rest of the term of his mother or her mother in jail. Is that social justice? Is that justice at all? I mean, forget about social justice. Is that justice at all? So, these are problems that we keep facing from time to time.
Judiciary will not offend the executive in performing things in the field of social justice. That there is a hung sword over the judiciary, that if it passes any controversial decree, order, judgment, anything, or a landmark thing, it will lead to offending the judiciary, the executive in a way, or the parliament in a way. The recent case of Justice Muralidhar being transferred, and there is no objection to it, although which has come in the newspapers. So, and the subsequent postponement of dates dealing with the Delhi rights, doesn't it lead to, justice delayed being justice denied in turn, which is implicit to judicial the social justice concept?
Yeah, you see, there is no conflict. There is no conflict in the implementation of social justice. The political dispensation, whatever party it is, whichever part of the country, they are also equally interested in the development of the country, like the judiciary. But sometimes it happens, like those instances that I have given you, sometimes it happens that the executive does not do its work when it should be doing it, then the judiciary intervenes. Sometimes it happens where the judiciary can also go wrong. It's not that everything that the judiciary does is correct. There have been instances where the judiciary has said in some states that there should be a road built over there. Now, that's not the job of the court to say whether there should be a road or whether it should be 1 lane or 2 lane or 4 lane road. That's certainly not the job of the court, that's the job of the executive. So there are lapses on both sides. It could be lapses on the part of the executive in not performing its duty. There could be a lapse on the part of the judiciary in doing or in passing an order which it should not normally pass. Right? So these conflicts are there. It is not something new. It has been there since 1950s. But the motive behind that is what is important. That is it being done for the development of society? Is it being done for the development of the country?
Lordship, I have one question regarding the juvenile justice. Like the recent we have seen in juvenile justice, 16 to 18 persons will be tried as adults. So, but there is a contradictory opinion, like the persons in case of consensual sex, 16 to 18 people, if there is a consent regarding the sex, they will be considered, it will be considered as a rape, and consent is not necessary. So here it is seen that persons do not have the capacity to think, they do not have social or informed choices to make. So why this contradiction even exists in the present scenario?
There are a large number in the judiciary, they call as love affair cases, where maybe one of the parties, the boy is perhaps below 18 or the girl is below 18, and they run away. This is certainly a gap, which has to be addressed at some point of time. I know that even before this law came, we used to get in the Delhi High Court also a large number of such cases, and the parties had to be spoken to. There would be counselling and so on. But you're right. This is a gap which I think needs to be addressed. It's not yet been addressed, but it needs to be addressed. The other thing, in addition to what you have said, is a child between the age of 16 and 18 committing an offence. I'm not talking about these love affair kind of things, but committing an offence, committing a heinous offence, like a murder, for example, or a rape. Then that child can, if the court is of the view that he was aware of the consequences of the act, be tried as an adult. Now, scientifically, it has been found that the development of the brain, takes a long time. It is fully developed around the age of 25 or so. So, it cannot be said with certainty that every child between the age of 16 and 18 knows what he or she is doing. Right? Sometimes it could be on an impulse. It could be could be sometimes for some different reason altogether. That again is a gap. But there are certain judgments where they have said that yes, this person should be tried as an adult. There are some judgments which say that no, this person did not understand the consequences of the act, so therefore should be tried as a child or as a juvenile in conflict with law. But these are gaps, which need to be addressed. I'm not sure, whether Parliament can address them, because these are issues which concern, the mental frame of a person. I don't know whether Parliament can address that, but certainly, there should be some research available, there should be some material available which can assist a judge in making up his or her mind when a case of this nature comes before the court. So, yeah, this is one of the grey areas in the Juvenile Justice Act.
My question is an independent judiciary a component or a prerequisite of rule of law?
See, the rule of law is one of the basic features of the Constitution, of the Constitution. So is an independent judiciary. So you cannot have a rule of law if the judiciary is not independent. And similarly, you can't have an independent judiciary if there is no rule of law. Right? So I think it's definitely an essential component of that. Certainly.
A very good morning to the question gathering present here. Respected sir.
Hello.
Respected sir, I want to raise an issue plaguing Indian judicial system, especially the apex court. In past few years, it has been seen that where the stakes are high, the Supreme Court had showed reluctance to act against the government. Like in the Aadhaar case,
the Supreme Court had shown
reluctance to act against the government of the day. Like in the Aadhaar judgment, Article 370 CAA, opaqueness in the working of the collegium. Given all these examples, it gives me an impression that, and with great respect and humility I am saying this, rather than working as an court of sentinel QB vis-a-vis fundamental rights, Indian Supreme Court is working as an executive court. Or simply putting in not telling what judges are more executive minded than the executive. Sir, it is not at all common for a former Supreme Court judge to write critically against the government. That is what you are doing. Respected sir. Sir, I want to know, like, which an institution is meant to protect the fundamental rights is failing to do so. Is there any hope left, or we are back to emergency era? But thanks to HR Khanna then, who dissented and showed us plan. Thank you, sir.
I'm not in full agreement with what you are saying. You see, you have judgments of the Supreme Court, and people can criticize them. You know, they can find, by criticism, I don't mean to say that you can say that this judgment is bad. You know, a judgment is something which has got reasons for it. The reasoning in a judgment is what is very, very important. So when you criticize a judgment, which you can, which anybody can, the criticism is towards the reasoning. Is the reasoning logical or is it not logical? Does it follow from what is enacted in the law, or does it not follow from what is enacted in the law? Or is there a correct interpretation of the law or an incorrect interpretation of the law? So to say that, well, you know, a particular judgment, you have mentioned the Aadhaar judgment, for example, you say it's a bad judgment or it's a wrong judgment. You have to find fault with the reasoning, you know, and say that for this reason that has been given by the Supreme Court, there is no logical sequence. And if that logical sequence had been followed, this would have been the result. So, and things like CAA, for example, that has not yet been decided also. So you can't really criticize any judgment, because there's no such judgment in that. So really, what has to be done is when you're dealing with the judgment, to criticize the reasoning of the judgment. There are occasions when perhaps some cases should have been taken up with greater urgency than they are. And speaking for myself, I do believe that there are certain cases that should have been taken up by the Supreme Court or by the High Court, Delhi High Court, with greater urgency, but they have not been taken up. You know, that is a little unfortunate. For example, you had the riots in Delhi, and the Delhi High Court adjourned the matter, I think, 13th of April or something. But the Supreme Court said that there is some urgency, please take it up urgently. It was a request made to the Delhi High Court. The Delhi High Court accepted that request. So these things happen. Not that they should happen, but these things happen. And that is why, an impression is gaining ground that the Supreme Court is like an executive court or something, which you have said. I think that's perhaps going a little too far. There are some errors that have been made. There are some misjudgments that have been made in terms of timing. But that doesn't mean that the Supreme Court is, executive minded or any such thing. And I'm not sure whether I would subscribe to that.
In the lawmaking, as well as the effective development of the jurisprudence by the courts, primarily in the fields of the social justice. Recently, we have heard a former judge quoting about judging under stress. Yesterday, Justice Muralidharan also quoted that it's upon a judge to be affected or not affected by such active involvement of media. So, how do you take it, and whether it is really depriving or affecting the development of jurisprudence with respect to social justice?
I'm sorry, I have not understood your question.
My question is with respect to judging under stress and the active involvement of the fourth pillar of democracy, whether it affects the jurisprudence or not.
I don't think so. Maybe at some level, perhaps subconsciously, yes, it's possible. All of us have influences, and we have to accept that. I have been brought up in a particular society, I have been brought up in a particular manner. So you have been brought up in a particular society and in a particular manner. So you have certain, certain ideas. I have certain ideas because of my upbringing. We may not agree, So, but the fact is that those ideas or those, prejudices or biases exist. And they can surface at some point of time. It can happen because of pressure or stress, as you say. It could be because of an outside influence, say from the media. It could also be you go to a wedding or something, you meet a friend and he says something, and that suddenly clicks your mind and says, yes, I'm doing a case of this nature, and this is the way I should look at it. So these are some things which are being debated and discussed by scholars on biases that judges have, hidden biases, or implicit biases. Sometimes they come out, sometimes they don't. But it does require a lot of debate and discussion. And it should not be, I would say, it should not be something which should be kept under the carpet. If a judge is biased, I think it should be known so that you get a fair decision.
My question is, do political beliefs of judges influence their verdicts, and has that ever happened to you?
Well, I don't think, at least the judges that I have come across over the last 20 years, I have not come across any judge who has had a political belief, or a strong political belief. I vote, like every other person I vote, but that doesn't mean that I have a political belief. I have not come across any judge who has a political belief or which he wants to put into practice. And certainly I have not been influenced by any political developments that have taken place. I am pretty clear about that. I have not been influenced.
That last year India faced 95 times internet ban in the country. Do you think it is a violation of freedom of speech and expression?
Yes, I think it is. Yeah.
Do you think that government should do that?
Sorry?
Do you think government should do that?
I don't think. I would certainly discourage a ban on social media. There are different ways of controlling social media. You see, for example, I know we had dealt with this case of circulation of videos on WhatsApp, sometimes even on the internet, where some person is being raped and a person is taking a film of that, and it's circulated on WhatsApp. I had gone to the law faculty in Delhi University 2 weeks ago, and I was told that in Meerut, close to Delhi, such kind of videos are available for 20 rupees. So the government can control it if they want to, whether it's on social media or whether it's otherwise. But ban is not necessarily the only answer. I think freedom of speech should be given full.
सर, जब भी कोई मुद्दा, कोई भी क्राइम नेशन वाइड इशू बन जाता है तो मीडिया में अक्सर ये सवाल उठता है कि आखिर न्याय प्रक्रिया में 4 साल, 5 साल या 10 साल या उससे ज़्यादा क्यों लगते हैं। तो मेरा आपसे वही सवाल है कि न्याय प्रक्रिया में इतना समय क्यों लगता है।
मेरा ये ख्याल है कि कोर्ट्स में केस मैनेजमेंट नहीं हो रहा है और केस मैनेजमेंट की बहुत ज़बरदस्त ज़रूरी है। और केस मैनेजमेंट एक्चुअली थोड़ा साइंटिफिक भी है, और अगर केस मैनेजमेंट इंट्रोड्यूस किया जाए ठीक तरह से तो ये जो डिलेज जो होते हैं 10 साल, 15 साल, 20 साल, ये सब खत्म हो जाएंगे। पर ये जुडिशरी को बैठ के सोचना पड़ेगा, इंट्रोस्पेक्शन करना पड़ेगा कि हम केस मैनेजमेंट कैसे इंट्रोड्यूस करें और अभी तक हमने क्यों नहीं किया है। उसके बाद इसका कुछ हल हो सकता है।
JNU happened, riots happened in Delhi, and continuing on the question my colleague asked, that steps were taken by some justices, judiciary did take it the cognizance, but certainly something did happen. That sword, that did come into motion, and the transfer was done. I'm not asking you to comment upon the transfer or to comment upon the constitutionality of the CAA, but the urgency that the judiciary needs to act with, sometimes suo moto or sometimes on such reports, to prevent such things from happening. 40 people have died. It
50,
could have
50.
Really, the toll has been increasing. It could have stopped at Shaheen Bagh. It could have stopped at JNU. But did we wait for lives to go like that, people to die, and then to understand that such steps or such action should be taken, or that should have be taken urgently or straight away when Shaheen Bagh was in motion?
Yeah. Well, if you have a look at today's Hindu newspaper, I have written about it. I have gone to the riot-affected areas 2 or 3 days ago, and I have expressed the view, which is there in today's newspaper, that in situations like this, the judiciary has to be more proactive. And if it had been more proactive at the appropriate time, perhaps a lot of lives could have been saved. I think the judiciary must act, with urgency in these kind of situations. Shaheen Bagh was a peaceful protest. It is still a peaceful protest. But what happened in northeast Delhi was not developed into a riot. So what has happened in Shaheen Bagh cannot be compared with what happened in northeast Delhi. They're two different things altogether.
The question is to which extent judicial activism can be demarcated, because there are many cases. For example, in Triple Talaq case, the dissenting opinion of Justice Kher and Nazir, they have mentioned that judiciary was going beyond its limit to an extent of legislating things. To which an extent, Your Lordship, the social justice with relation to the activism of judiciary can be demarcated?
It's very difficult to have a demarcation line. You can't say that this is the Lakshman Rekha. It's very difficult to lay down that line because it depends upon each case. Social justice is actually transformation of justice for the benefit of society. The transformation of society through the process of justice. So, on some occasions, maybe some judges have a particular point of view or a point of understanding on how to provide social justice. There may be a difference of opinion with somebody else. You have the difference of opinion in Triple Talaq, you have the difference of opinion in Sabarimala. So, you can't have a demarcation line. I don't think that's possible.
Lordship, all of us would like to know what is the difference between the judicial system and all other things like pendency and all between these two countries. And nobody can explain other than you since you have been.
Yeah. Okay, the Fiji was also a British colony like India. And they have also gained their independence. It is a member of the Commonwealth. So it follows the same common law jurisprudence that we follow. So in that sense, in the legal system as such, there is not much of a difference. But they have a difference in nomenclature and practices and pendency. The population of Fiji is 9.5 lakhs. So it is a very, very small country. And the main population is in 2 separate islands. So to come from one island to another island, can take about 2 hours, depending upon the sea, whether it is rough or not. But they have a very strong judiciary at the lower levels, at what we call district level. There, the district judges are actually called High Court judges. So there is this difference in nomenclature, but the High Court judges also has, like we have in India, we have magistracy and we have the sessions, the additional district judges. So their High Court also has two different levels. An appeal from the High Court will come to what is called a Court of Appeal. And there's only one Court of Appeal with, I think, about 9 judges. And against the decision of the Court of Appeal, there is the Supreme Court of Fiji. Because it has a very small population, the number of cases are also very few. So I had gone for a session in August last year, and there were 4 judges from different parts of the country, from different parts of the world. There was one judge from England, one judge from Sri Lanka, one judge